Hi, I'm Anna Denton-Jones, and today I want to talk about a recent Employment Tribunal claim in Manchester that was successfully brought for unfair dismissal by a postman. What had happened is he lived separately from his daughter and had access arrangements that he would see her on weekends. At the time that arrangement came about, he made an application to his line manager to ensure that he would only have to work Monday to Fridays. In effect, a flexible working request that was agreed. A couple of years later, the Royal Mail were then having a reorganisation, and the working pattern that was presented to him and his colleagues at that time would have seen him work 3 out of every month Saturdays. He obviously didn't want to change to working that arrangement, so he put in a second flexible working request at that point, looking to keep his Monday to Friday working pattern, and was unsuccessful in doing that, eventually ending up going off on the sick, raising a grievance, and ultimately being forced by the Royal Mail to work the pattern that they wanted. Obviously this all took some time, but eventually he resigns as a result of them still maintaining that he has to work those Saturdays. It was interesting in the judgment that the judge pointed out that from the Royal Mail's perspective, it wasn't an impossibility that he could work Monday to Fridays only. It was more something that was going to be inconvenient to them, perhaps cost them more, give them more of a headache, but it wasn't actually an impossibility. Obviously, talking about a very large organisation that could have juggled people's working patterns. When they rejected his request to work flexibly, they'd used the business reason. You know, there's 8 business reasons that you can reject somebody's flexible working request. They'd sought to argue that it was, we can't reorganise work amongst our existing staff. So he was successful in his claim. He had about £22,000 worth of damages, including £4,000 worth of costs against the Royal Mail. And I think the message that we can take from the case is that, first of all, if you have already agreed a flexible working pattern with somebody, they've obviously got a legitimate expectation of being able to continue working in that pattern. We need to take care then about being able to justify perhaps removing or changing that established working pattern, particularly where there are childcare reasons connected with it. The second thing is that because it's a large organisation, this idea of, you know, we have to have everybody working the same pattern, we can't possibly have any differences, is perhaps a little bit outdated now, and organisations really are expected to show some flexibility on their side as well. So, you know, we're used to making reasonable adjustments for people with disabilities. You know, we are expected to treat individual cases on their merits and not just have a sort of one size fits all, and to be very careful really around making people work patterns that are going to give them real difficulties in their personal lives. And this is something, if you are making changes to your contract, that you do need to think about, particularly if you are a large organisation. I think if you're smaller, you're much more likely to be able to say, you know, we have to have our staff working these particular patterns because there are already a few of us. We can't do it any other way. But I think if you work in a big organisation, it may be difficult to continue to justify these sorts of arrangements. If you've got any questions, please do give me a call or email me adenton@refreshinglawlimitedltd.co.uk. Thanks.